Hello friends, in the series on the income tax cases, today we will discuss a matter that whether an assessee has a right to approach the Commissioner of Income Tax under section 264 in a case where assessee has filed his income tax return by taking some amount as taxable in case that amount was not taxable. Whether assessee can go to Commissioner of Income Tax for the revision of that mistake. Section 264 is there if the order has been passed against the assessee which is prejudicial to the interest to the assessee, then in that case the assessee can approach the Commissioner of Income Tax for revision. So even if the return has been filed, the intimation under section 143 subsection 1 has been issued or not, can assessee approach to the Commissioner under section 264 to rectify any type of this type of mistake? This issue has been taken by Gujarat High Court in the case of Jindal Worldwide Limited versus Principal Commissioner of Income Tax, and this case has been reported in 466 ITR at page number 672. The matter has been decided on 29th April 2024. The facts of the case are very interesting. In the present case, the assessee filed his income tax return for the assessment year 15-16 by including some subsidy into the revenue. After some time, the judgment of the Supreme Court came to the knowledge of the assessee, which was decided on 2018, and the name of the case is Commissioner of Income Tax versus Chaphalkar Brothers, which has been reported in 400 ITR at page number 279. In that judgment, the Supreme Court decided the character of the subsidy, that in what cases the subsidy should be revenue or in what cases the subsidy should be capital. The assessee, on the basis of that Supreme Court judgment, for some another assessment year of the assessee, that is assessment year 12-13, whose case was pending before the tribunal of the assessee, took an additional ground, and that additional ground of the assessee was admitted, and the order was passed accordingly on 20th February 2019, meaning thereby that on the basis of the Supreme Court judgment, the assessee gets done for the assessment year 12-13, which was decided on 20th February 2019, and after that, on 1st July 2019, the assessee filed the revision application with the Commissioner of Income Tax, which was rejected by the Commissioner on 20th March 2020 by saying that it has been submitted late. The assessee do not have the option other than going to the High Court by filing a writ petition. When this matter was heard by the Gujarat High Court was of the considered view that the assessee has a right to approach the Commissioner of Income Tax when he is not able to reach appellate authority and do not have any other alternative remedy. The Gujarat High Court also said that in the present case, the Commissioner of Income Tax has wide power to condone the application for revision, and the Commissioner should not take the pedantic approach, especially in those cases where there is no negligence is imputable on the part of the assessee. The court said that in the present case, the assessee has erroneously considered some subsidies as revenue instead of capital, and since the assessee has filed the revision application, the Commissioner of Income Tax do have the power to condone that, and he should have condoned that application. So the Gujarat High Court remanded the matter back to the Commissioner of Income Tax to hear the matter on merits, and said that the Commissioner should not take a very narrow approach in condoning the application. So friends, from this case, two things are very clear: that the assessee has the right to approach for revision under section 264 even on some assessment orders have not been passed, if the assessee has taken some income which is not taxable in his taxable income. At the end of this video, once again I am repeating the name of the case. The name of the case is Jindal Worldwide Limited versus Principal Commissioner of Income Tax, and this case has been reported in 466 ITR at page number 672, and the matter has been decided by Gujarat High Court, and the date of the judgment is 29th April 2024. Thank you, friends.